Chapter 4 of the South African Law of Persons, 6th edition by Jacqueline Heaton. The topic of Chapter 4 is domicile. Under Chapter 4, we have 4.1, Introduction, 4.2, Replacement of the common law rules on domicile by the Domicile Act 3 of 1992, 4.3, Definition of domicile, 4.4, General principles governing domicile, 4.5, Kinds of domicile, 4.5.1, Domicile of origin, 4.5.2, Domicile of choice, 4.5.3, Assigned domicile, or in brackets, domicile by operation of the law, domicile of closest connection. These topics are covered in pages 39 to 47. 4.1 Introduction. As legal systems differ, it is one of the utmost importance to establish which legal system determines a person's status. In many legal systems, a person's private law status is determined by the law of the country of which he or she is a citizen, that is, the person's nationality. See footnote 1. In South African law, however, a person's status is generally determined by the law of the place where the person is domiciled. That is, the person's lex loci domicilii, lex domicilii, or domiciliary law. See footnote 2. The definition of lex loci is basically the law of the place of domicile. Thus, for example, a person's lex domicilii determines whether he or she is a minor. See footnote 3. The question of whether a child was born of married or unmarried parents is determined by the law of the place where the child was domiciled at birth. That is, the child's domicile of origin. See footnote 4. A person's lex domicilii is also important in the law of succession. For instance, the law of interstate succession of the country in which the deceased was domiciled at the time of his or her death determines how his or her movable property devolves if he or she died without having made a valid will. That is, if he or she died interstate. See footnote 5. The lex domicilii of the testator at the time of executing a will determines whether he or she has the capacity to dispose of his or her movable property by means of that will. See footnote 6. Domicile also plays a role in respect of due restriction. For instance, matters regarding a person's status must, as a rule, be heard by the court having jurisdiction in the area where the person is domiciled. See footnote 7. Domicile is also a factor in determining whether a foreign judgment can be enforced against a person in a local jurisdiction. See footnote 8. The lex domicilii also plays an important role in respect of the patrimonial consequences of a marriage, because the lex domicilii of the husband at the time of the marriage determines the spouse's matrimonial property system. Patrimonial in law refers to property or assets that have monetary value including rights, duties, and expectations that can be quantified financially and are often inherited from ancestors. So it encompasses the patrimony or patrimonial estate of a person, which is the sum total of their assets and liabilities. So, for example, we say a patrimonial loss is calculable reduction in a person's estate due to damage to property or destruction of earning capacity. See footnote 9. Take the example of a man domiciled in South Africa who marries a German woman in Germany while studying there. The patrimonial consequences of the marriage are determined by South African law. This means that the marriage is in community of property unless the parties concluded an antenuptial contract. See footnote 10. The rule regarding the husband's lex domicili as the determining factor in respect of the matrimonial property system applies to sexual civil unions too. See footnote 11. However, it fails to cater for same-sex civil union partners. In such unions, there is no husband, in quotes, whose lex domicili can be used, because the parties to the civil union are either two males, two husbands, or two females, two wives. See footnote 12. This failure unjustifiably limits the right to equality that is protected by Section 9 of the Constitution. It, inter alia, we remember that means among other things, unfairly discriminates against same-sex civil union partners on the ground of their sexual orientation by leaving the proprietary consequences of their civil union uncertain. So proprietary just loosely means ownership or to own. See footnote 13. Even in the case of heterosexual spouses and heterosexual civil union partners, the rule unjustifiably limits the equality clause, for it constitutes unjustifiable, unfair discrimination on the ground of sex. See footnote 14. Therefore, the rule should be declared unconstitutional. Unfortunately, South African private international law does not currently have a ready replacement for the rule. See footnote 15. It is submitted that the legislature should step in as a matter of urgency to enact a suitable and constitutionally acceptable rule. See footnote 16. 4.2 Replacement of the common law rules on domicile by the Domicile Act 3 of 1992. In the past, the law of domicile was governed by the common law, and uncertainty prevailed on many aspects relating to domicile. For this reason, the South African Law Commission, which is now called the South African Law Reform Commission, investigated domicile with a view to reforming this branch of the law. See footnote 17. Its investigation and recommendations culminated in the Domicile Act 3 of 1992, which came into operation on the 1st of August 1992. The Act solved many, but not all of the problems with regard to the law of domicile. For example, it remains unclear whether someone can have more than one domicile at the same time. It is also unclear whether military staff, diplomats, public servants, Employees of foreign governments or businesses and prisoners are competent to establish a domicile of choice in terms of the Act or whether the common law still applies to them. These issues are discussed below in the chapter. It should also be noted that the Act is not retrospective. It accordingly does not affect any right, capacity, obligation, or liability which was acquired, accrued, or incurred by virtue of the domicile a person had at any time prior to 1 August 1992. So just quickly here, acquired would mean obtained, accrued would mean growing or adding to, like adding to debt. Incurred would mean to become liable or subject to. Back to the topic. Nor does it affect the legality of any act performed before the date. See footnote 18. For example, in Lenferna against Lenferna, see footnote 19, which was decided in 2013, the issue of whether the husband had a domicile in South Africa at the time of the spouse's marriage had to be determined in terms of the common law because the marriage was solemnized in 1983. And just quickly here, solemnized means to perform an official or legally recognized ceremony. 4.3 Definition of domicile. A person's domicile is the place where he or she is legally deemed to be constantly present for the purpose of exercising his or her rights and fulfilling his or her obligations, even in the event of his or her factual absence. Although a person's domicile frequently coincides with the place where he or she permanently resides, permanent residence is not the same as domicile. Thus, the fact that somebody is permanently resident in South Africa does not necessarily mean that he or she has a domicile here. 4.4 General Principles Governing Domicile. Every person must have a domicile at all times. See footnote 20. In other words, no one can never be without a domicile. Whether someone can have more than one domicile at the same time has not been finally settled in our law. For example, can a person who lives in Pretoria for 6 months of the year and in London for the other 6 months of the year have 2 domiciles? According to our common law authors, the answer would be yes. See footnote 21. However, obiter dicta in some of the decisions of our courts indicates that a person cannot have more than one domicile at a particular time. See footnote 22. Also, if we can remember, obiter dicta means a judge's expression of opinion uttered in court or in a written judgment. In Alon against Alon, see footnote 23, the Appellate Division, now the Supreme Court of Appeal, referred to the issue but did not have to decide it. The Law Commission did not deal with this matter in its report on domicile. Because the Domicile Act was based on the recommendations contained in the Law Commission's report, it too is silent in this regard. Most modern South African authors, however, submit that a person cannot have more than one domicile at the same time. See footnote 24. In terms of Section 3, subsection 1 of the Domicile Act, no one loses his or her domicile until he or she has acquired another domicile. A change of domicile is never simply accepted. It must be always proved. See footnote 23. Whether a person has acquired or lost a domicile is determined on a balance of probabilities. See footnote 26. 4.5. Kinds of domicile. Our law distinguishes between the following kinds of domicile. 4.5.1 Domicile origin. A person's domicile of origin, also called the person's original domicile or domicilium originis, is the domicile the law confers on the person at birth. In the past, a person's domicile of origin revived if he or she abandoned his or her domicile of choice without assuming a new domicile. In such event, the person's status was determined by the law of his or her domicile of origin until such time as he or she assumes a new domicile of choice. See footnote 27. Thus, the person's domicile was neither based on the place where he or she physically resided, nor was it connected with his or her intention. It was simply a domicile that was assigned to him or her by operation of law for reasons of efficacy. The Domicile Act changed the position. Section 3, subsection 1 of the Act provides that no one loses his or her domicile until he or she has acquired another domicile, whether by choice or operation of law. Section 3, subsection 2 of the Act expressly provides that a person's domicile of origin does not revive, although a person can have a domicile where his or her domicile of origin was, if he or she acquired a domicile of choice there. See footnote 28, or if he or she does not have the capacity to acquire a domicile of choice and the law assigns a domicile to him or her. See footnote 29, at the place where his or her domicile of origin was, because he or she is most closely connected with that place. Thus, for example, a child who is born in South Africa and lives with his or her parents in this country acquires a domicile here. If the child moved permanently with his or her parents to Egypt, he or she would acquire an assigned domicile in Egypt. If, as an adult, he or she left Egypt with the intention of never returning to that country and lawfully returned to South Africa with the intention of indefinitely living here, he or she would once again obtain a South African domicile. However, his or her South African domicile would be a domicile of choice. It would not be his or her domicile of origin that revived. Because of the provisions of the Domicile Act, domicile of origin has lost most of its significance. A person's domicile of origin is still relevant insofar as it determines whether the person qualifies as a child born of married parents. See footnote 30. As a person's domicile of origin is purely the first domicile assigned to him or her, it might just as well be categorized simply as an example of an assigned domicile. That is a domicile by operation of law. See footnote 31. 4.5.2 Domicile of choice. A. Definition. A domicile of choice is the domicile that a person who has capacity to act has chosen for himself or herself by exercise of his or her free will. B. Persons who can acquire a domicile of choice. Section 1, subsection 1 of the Domicile Act provides that, regardless of sex or marital status, everyone who is of or over the age of 18 years and everyone under the age of 18 years who legally has the status of a major is competent to acquire a domicile of choice unless he or she lacks the mental capacity to make a rational choice. Therefore, the only persons who can acquire a domicile of choice are adults, that is, persons who are 18 years or older, and minors, that is, persons below the age of 18 years who have acquired majority status. See footnotes 32 and 33. A minor can acquire majority status by entering into a marriage. See footnotes 34. As minors are expressly excluded from concluding civil unions, they cannot acquire majority status by concluding a civil union. See footnote 35. The second requirement set out in Section 1, subsection 1, is that the person must have the mental capacity to make a rational choice. Consequently, a mentally ill person or a person with a serious intellectual disability cannot acquire a domicile of choice. See footnote 36. Fortunately, sex and marital status no longer play a role in the acquisition of a domicile of choice. At common law, a wife automatically acquired her husband's domicile at marriage and followed it whenever he changed it, irrespective of whether she was present at the particular place or whether she had the intention of residing there permanently. See footnote 37. This rule applied even if the spouses were living in different countries. The wife's domicile was called a domicile of dependence. A minor also had a domicile of dependence, which was the domicile of his or her guardian. Now, as is explained below in this chapter, a minor has an assigned domicile which does not necessarily correspond to his or her guardian's domicile. C. Presence and intention as requirements for acquiring a domicile of choice. Section 1, subsection 2 of the Act provides that a domicile of choice is acquired by a person when he is lawfully present at a particular place and has the intention to settle there for an indefinite period. The section thus sets two requirements. One relates to being lawfully present at a particular place, and the other relates to the person's intention about the duration of settling at the particular place. At common law, these requirements were respectively called the factum and the animus requirement. These two requirements must at some time or another exist simultaneously, but they need not come into being simultaneously. See footnote 38. A person may therefore first settle at a place and only later form the intention of residing there indefinitely. Once a domicile of choice has been established at a particular place, the person does not have to be continually present at the place in order to retain the domicile. See footnote 39. Let us consider the two requirements in section 1, subsection 2 in more detail. Point 1. Lawful presence. To comply with the first requirement in section 1, subsection 2, the person must actually settle at the particular place where he or she wants to acquire a domicile of choice, and his or her presence there must be lawful. It is important to note that this section only recognizes lawful presence for purposes of acquiring a domicile of choice. See footnote 40. An illegal alien, also a prohibited immigrant, can therefore not acquire a domicile of choice in South Africa despite having the intention of settling here permanently. See footnote 41. However, in Van Rensburg versus Ballinger, see footnote 42, the court held that a prohibited immigrant whom the authorities had openly permitted to reside in South Africa could acquire a domicile of choice here. A person who has applied for refugee status in South Africa is not in the same position as an illegal alien. See footnote 43. While the person's application for refugee status is being considered by the South African authorities, he or she is lawfully present in the country. See footnote 44. Therefore, he or she can meet the requirement of lawful presence for purposes of acquiring a domicile of choice. Persons who are deported from South Africa lose their domicile in this country, even if they intend returning, because their return would be unlawful. See footnote 45. It has been held that a person who has acquired a domicile at a particular place and who subsequently leaves that place in order to escape from the process of the law, in other words, someone who becomes a fugitive from justice, does not lose his or her domicile at the place from which he or she has fled. See footnote 46. The object of this rule is to preclude the fugitive from relying on the courts not having jurisdiction to hear the matter, thereby escaping the consequences of his or her misconduct. It must be borne in mind that in this instance, the fugitive's residence has not been rendered unlawful. He or she has fled in order to escape the legal consequences of his or her actions. This case, therefore, differs from that of the illegal alien. In order to establish whether a person meets the requirement regarding physical presence, the situation is viewed objectively. See footnote 47. A specific period of physical presence is not required, but the person must not simply be visiting the place where he or she wants to acquire a domicile of choice. See footnote 48. If it is established that the person was indeed physically present at a specific place where he or she intended to stay, and that his or her residence was lawful, the duration of his or her residence there is irrelevant. However, the courts sometimes take the duration of the physical presence into consideration to infer whether the person had the intention of remaining at the specific place, that is, whether the person had the animus manendi. See footnote 49. Point number 2. Intention to settle for an indefinite period. The second requirement in Section 1, subsection 2, provides that a person can acquire a domicile of choice at a particular place if he or she has the intention of settling there for an indefinite period. See footnote 50. Thus, a person can satisfy this requirement even if he or she envisages moving at an unknown future time. See footnote 51. To establish whether the person complies with the requirement, a subjective test is used. See footnote 52. In other words, the intention of the particular person is determined. To satisfy the requirement, the person must be able to carry out his or her intentions of settling at the particular place. See footnote 53. The fact that a person who has applied for refugee status has precarious residence because the application might be dismissed does not disqualify the person from acquiring a domicile of choice, but it is a factor that is taken into account in determining whether he or she can have the intention to settle for an indefinite period. See footnote 54. Military staff, diplomats, public servants, employees of foreign governments or businesses, and prisoners were initially considered incapable of acquiring a domicile of choice at the place where they were stationed, posted, or imprisoned, on the ground that their employers or the state determine whether they are to reside and that they therefore cannot give effect to their intention of settling at a particular place. The Domicile Act does not expressly deal with the acquisition of a domicile of choice by someone who is not free to decide where he or she wants to reside. No provision expressly excludes a person whose presence at a particular place is not originally by choice from acquiring a domicile of choice there. It could therefore be argued that, like any other person over the age of 18 years who has the required mental capacity, such a person should be competent to establish a domicile of choice in terms of Section 1 of the Act. See footnote 55. Consequently, the mere fact that someone has been posted to or is stationed or imprisoned at a specific place should not render him or her incapable of having the required intention to acquire a domicile of choice. I prefer this view. See footnote 56. In contrast, it could be argued that because the Act does not expressly state that people like military staff, diplomats, public servants, employees and officers of foreign governments and businesses, and prisoners can meet the requirement regarding intention even though their employment or imprisonment limits their ability to give effect to their intention. The common law still applies in this respect. As it is unclear which argument will be preferred by the courts, the common law position is briefly summarized below. Military staff. It used to be generally accepted that foreign military staff could not acquire a domicile of choice in South Africa, however much they wished to settle here permanently. In Macmillan, against Macmillan, see footnote 57, The reason given for this attitude was that the person's residence here was not voluntary, but was prescribed by a foreign power. In 1945, the Appellate Division in Baker against Baker, see footnote 58, opened the door to a new approach. It held that soldiers can acquire a domicile of choice at a place where they are not stationed. Although the court declined to answer the question of whether soldiers can acquire a domicile of choice where they are stationed, the erstwhile Transvaal and Cape courts subsequently interpreted obiter dicta in the judgment as being authority for the view that this is possible. Diplomats, public servants, and employees and officers of foreign governments and businesses. Originally, foreign diplomats, police officials, public servants, and employees and officers of foreign businesses were also denied a domicile of choice in South Africa while they were in the service of the foreign government or business. See footnote 61. In Neville against Neville, see footnote 62, the Cape Court decided, however, that a foreign diplomat could acquire a domicile of choice in South Africa while still in the service of a foreign country. The same should apply in respect of public servants and employees and officers of foreign governments and businesses. Prisoners. It has been argued that a prisoner cannot acquire a domicile of choice at the place where he or she is imprisoned, since he or she is not there of his or her own free will. See footnote 65. In Neffler against Neffler, see footnote 64, it was however held that a prisoner who had been imprisoned for life automatically acquired a domicile of choice in prison. 4.5.3 Assigned domicile, in brackets, domicile by operation of the law, domicile of closest connection. Section 2, subsection 1 of the Domicile Act provides that anyone who does not have the capacity to acquire a domicile of choice is domiciled at the place with which he or she is most closely connected. Minors and people who do not have the mental capacity to make a rational choice cannot acquire a domicile of choice. See footnote 65. The law assigns a domicile to them for as long as their minority or mental incapacity lasts, and that domicile is the place with which the particular person is most closely connected. This type of domicile is called an assigned domicile, a domicile by operation of the law, or the domicile of closest connection. A. Domicile of a minor. By virtue of the provisions of Section 2 of the Domicile Act, a minor is domiciled at the place with which he or she is most closely connected. Section 2, subsection 2, contains the rebuttable presumption that if a minor normally has his or her home with one or both of his or her parents, the parental home is the minor's domicile. Section 2, subsection 3 of the Act expressly provides that the term parents includes a child's adoptive parents and parents who are not married to each other. A domicile is assigned to a minor only if he or she is unmarried. See footnote 66. When the minor attains majority, or if he or she acquires the status of a major by getting married, he or she retains the domicile he or she had by operation of law until he or she establishes a domicile of choice. B. Domicile of a mentally incapacitated person. Formerly, the courts adopted the view that mentally incapacitated persons retained the domicile they had when they became mentally incapacitated. See footnote 68. In contrast, some authors were of the opinion that it would be better if mentally incapacitated persons followed the domicile of their curator if one had been appointed. See footnote 68. The issue had been resolved by the Domicile Act, which provides that persons who do not have the mental capacity to make a rational choice, in quotes, cannot acquire a domicile of choice. See footnote 70. Instead, they acquire a domicile at the place with which they are mostly connected. See footnote 71.